how are wills or trusts challenged in court? That's what we're going to be talking about today in this video. The law says is that if any part of a will or a trust was procured by fraud, duress, undue influence, or a mistake, these are all kind of different causes of action that someone can bring, then the will or the trust will be deemed void. So let's dig deeper into it, because what happens is some people will challenge things like testamentary capacity. I did another video that talks about what is testamentary capacity, which is were they able to sign a will in the first place. But because a will can only be challenged after somebody passes away, meaning there's no such thing as a will challenge while the person who created the will is alive, because they have the right to do whatever they want before they can revoke the will or change the will before they pass away. So the challenges can only arise after they pass away. Most people aren't doing it under the cause of action of lack of testamentary capacity. Most people are bringing those claims in the form of claiming undue influence, okay? And the presumption, it's actually fairly easy to bring an undue influence claim, because there is a presumption of undue influence if you can show that the alleged undue influencer meets three factors. You need all three factors, which is, were they a substantial beneficiary under the will? B, did they occupy a position of confidentiality? Did they have a close confidential relationship with the person who signed the will? So that might be a child, could be a caregiver, it could be someone who's a fiduciary, like a power of attorney. And 3, were they active in procuring the will? And to determine whether someone's deemed active in procuring the will, we look to a Supreme Court case called Carpenter, which laid out what we call the Carpenter factors. And I don't have them memorized. I have some notes up here that I'm gonna read from. But Carpenter was in 1971 that shows these 7 non-exclusive factors to show that someone was actively helping to procure the will, which is, was there the presence of the beneficiary, who's the alleged undue influencer? Were they there when the will was signed? This is one of the biggest factors that the courts will look at, because it's hard to raise your hand and say, I don't really want to do this, if you have the person who's undoing influence who's sitting there in the room with you, which is why in our office, we tell families in advance, say, listen, when it comes time to signing, we're going to ask everybody to wait outside. They're going to be in the lobby. They're not going to do this in front of, because we want to give our client the ability to say, hey, this is really not what we want to be doing right now, okay? And this is to protect everybody, so that no one can use this Carpenter case against our clients, okay? Was the attorney the attorney who made the will recommended by the person who is benefiting from the will and is the alleged undue influencer? And that is quite often the case. That happens all the time. There's, especially with the population that I serve, mostly the elderly, these are folks who typically rely on their children for advice. So again, just because you ask your son or daughter to help you find an attorney to make a will is not going to lead to this. But this is why we want to take precautions to make sure that we're having consultations where the children are not in the room, and we're giving the client plenty of opportunity to say, hey, is there something you want to tell us? That's why I'm attorney-client confidentiality bound, that I would not tell your son or your daughter. Is there anything you want to tell me before we proceed with talking about this will, or before we create a will, before we draft the will, before we sign the will, right? These are all very important things that an attorney is doing, not to insult the family, but it's to protect the client and to protect the family from these sorts of claims. Was the beneficiary, who's the alleged undue influencer, given a draft of the will to review alongside or in lieu of the actual client, right? Sometimes the kids are saying things like, no, just send me the will and I'll talk to mom about it. No, we can't do that. We have to send it to mom. We got to send it to dad. They have to be the ones to review it. And if they choose to share it with you, that's absolutely something they're allowed to do. Was the beneficiary the one who secured the witnesses, right? In order for a will to be valid, there have to be 2 witnesses present when the person creating the will actually sits down to sign. And are those witnesses friends or close associates or brought in by the beneficiary, who's the undue influencer. And who's keeping the will? Who's holding on to the will after it's signed? And sometimes parents say to their children, I don't want to be responsible for this. You're going to be the one in charge. I want you to hold on to it. That is one of the factors that can be used against the child if they're the primary beneficiary, especially to the exclusion of other siblings or other individuals who believe that they should be receiving money in the form of an inheritance. Okay? And these are essentially what we call the Carpenter factors. So when someone is contesting a will, contesting a trust, they're usually doing it using the theory of that there was undue influence. So when preparing a will or preparing a trust, you want your estate planning attorney to be very diligent in protecting the client and protecting the family from these sorts of claims. Hope you found this video useful. If you did, please subscribe. I have all sorts of practical content that relates to the world of Florida estate planning, Medicaid planning, or probate. And thank you very much for watching.